agreement is used, how voluntary is voluntary? I mean,
well, it's in the voluntary is voluntary is used in the context of there's not a road preservation program in place that requires a developer to enter into a road use agreement. What it means is that in recognition of either impacts that may be created as a result of the project, or and as a means of creating an efficient relationship between the municipality and the developer, a road use agreement was entered into to identify the rights and responsibilities of both parties.
Okay, well, we have in place zoning that precludes gas drilling.
Yep.
But that doesn't mean we won't have traffic going to other
Correct.
places.
Correct.
A developer says to us, so what? I'm going through your town.
Mm-hmm.
What? How do we force a road use agreement with that?
Well, you can't force a road use agreement on anyone. By its nature, it's an agreement, and therefore you have to have two willing parties. So the local road preservation programs we work with use a local law to create standards and requirements that certain traffic is subject to. And again, those are things that are called jurisdictional triggers. What makes that traffic have to meet these standards and requirements? So what you want to do is say, okay, in what we've done with towns is to say there's construction activity that needs a permit from a state, local, or federal agency, and that your type of traffic is distinguishable from our everyday traffic because of these characteristics, and those characteristics are set forth in the law. And so that makes that traffic have to meet those standards and requirements. Now that developer or has a choice of saying, okay, I'll just meet the standards and requirements, which requires insurance and security and all those things, or I'll enter into an agreement to make to make it work more efficiently. Most of the times, developers I know will work into an agreement because they want to. Often the developer, I'm Mr. Driller, and I have Mr. Trucker working for me, but he's not an employee of my company. So I want to say to that trucker, here's the agreement we have with the town. You need to meet these standards. And I can, in my contract with Mr. Trucker, I can then impose those standards on him or compliance with these standards to make sure that it carries through. So that's how you want to do it. You want to make sure that you're identifying the nature of the traffic that's subject to that law and imposing the standards. The agreement is really a means of implementing those standards and ensuring compliance with them. If the developer or the trucker decides, I don't want to go into an agreement, then it's up to the municipality to observe and enforce using the powers that it has under the law and under the VTL and other things like that.
Okay, Don, I'm going to put you on hold because there are one person behind you who hasn't spoken yet. Did you raise your hand?
What's an indemnity? What's an indemnity?
An indemnity is a provision in a contract which basically says that I am going to hold you harmless if the activity that I'm undertaking causes damage, injury, or unfortunately death to anyone, then I will indemnify you, meaning I will bear any costs associated with that. And so basically it's basically making sure that you're not bearing costs caused by the other side. Under New York law, there's certain limitations that you cannot be indemnified for your own negligence. So you should never accept from a developer something to the effect that says, well, town, we're going to do all this stuff and we're going to make this wonderful, but you're going to pay for whatever we do. No, that doesn't work. Basically, you want the developer to cover your costs of both legal defense and any damages that are awarded or result from that activity.
Can this presentation be emailed as an attachment?
Yes, it can. Just please sign up before you leave with your email address, and I'd be happy to send it.
Thank you. I just wanted to respond to the question about how you get someone to come visit your town board if you want to get a road use agreement. Although this is an enforcement issue, and I don't want to minimize that, if you post the road that they're using for weight limit and it's through traffic, they're not going, then that's your right to do. And if you can get someone to enforce that and to keep them off the road, they'll have to come and visit you, because the only way to get over that is to have come in and meet with you to go through it. And a question that I have is, as we've learned from Lynn and from some of the things you've talked about, that all roads are not created equal, not even
Correct.
Sections of roads are created equal. and also that roads don't obey any laws that we make other than the laws of nature. And so the trigger concept is really important, and maybe you could spend, or Mike could spend a little time just talking about what you see out there for triggers, what works, what doesn't work. Thank you.
Well, the legal jurisdictional trigger is different. I think what you're kind of getting at is there a physical condition of the road that would warrant application of a particular aspect of a program? And that's a little bit of a different animal. What I was talking about in terms of triggers are the legal means by which saying you're subject to this program. As far as the specific engineering issues, I think that's where having an engineer-based program where you're going to look at it and say, you know, just because this section of the road of Smith Street is built up and it's well and good, you know, a mile down the road it turns into a dirt road. So how do we deal with that? And then, you know, so that's where having both, you know, a comprehensive program is really important, that with people and the expertise that are going to be able to look at the road, you know, holistically and understand that, well, each part of it is different, and we have to understand what the conditions are and what the impacts will be. There was a question back here.
Go ahead if you can shout, otherwise I'm coming.
I'll wait for you. Thank you. With respect to the preliminary engineering analysis where you're establishing your baseline data and acquiring information as to whether the roads can withstand this type of heavy truck traffic in the first instance, can that analysis, that cost, be transferred to the developer? Right now, I know that the towns, most of them are forefronting those costs, and so I'm just wondering, for towns that are reticent to do so and are waiting, is that something that through their local law they can ultimately transfer to the developer?
That's a good question, and basically the issue is you have to look at what the nature of the evaluation you're doing on a preliminary basis. The preliminary basis and the evaluations that we're working with on all the towns where we represent with Delta is something more of a general nature that assesses, well, your roads fall into a certain classification of risk, that if this type of traffic comes in, then this portion of your road network is more at risk, and that should make sure that there's attention there. It's not a detailed, drilled down evaluation of, you know, segment by segment by segment of what the conditions of those roads are, because doing that would be a waste, because if nothing occurs for a year or 2 years, it might change. So what we've tried to do is pare it down as low as possible to give the municipality a fundamental understanding of what they're facing. Now, the ability to transfer that cost to a developer, the only way I could see that occurring is if you waited until a developer comes in and then says, okay, we want to do this. Now, the problem with that is if they come in and you say, well, wait a minute, I want to do a road program, you know, then you're like, okay, there's time involved. There's, you know, are they going to challenge it? You're doing it in the face of my project, all of these other issues that go along with it. So you want to look at it and say, you know, is it an investment in what we're trying to do? You could try to, you know, I mean, because really that more detailed analysis is going to be done when a developer comes to you, and that will be paid for by the developer, which will be more expensive, more in-depth, more detailed. So it's, you know, what we've tried to do, and there's always, you know, ways to work it out, is, you know, is to go in and minimize your expenditure at the forefront. But I mean, at the base, I would say it's necessary to have you want to have a program in place. If you think this is an issue worth addressing, put your program in place before the activity occurs, so they're on notice and you're on notice. The most confrontational way this can occur is if something gets put up on the eve or the 11th hour of activity ready to occur. People are mobilized, schedules are in place, money's being spent, and then you hit them with a 2 or 3 month lag. That's when they're going to get angry and try to potentially undermine the program. It could be easier for them to try to undermine your program than to comply. So you want to encourage compliance and set the table where efficiency for both the town and the developers are maximized.
Can you give a general idea of what the cost to a town would be for a general analysis ahead of time?
Basically, the towns that we've worked with, in order to do, when we've worked with Delta, you go in and there's basically what they call, there's 3 phases of the approach. Phase 1 is the basic assessment and the delivery of legal documents to get them in place. So the first chunk of it, I believe, is $8,500 is what, or $9,500, which includes both the engineering and legal components for that initial phase. And what that will enable, together. And it basically, what it'll be is you go in with the engineering company, and in this case Delta, and they would go in and they do that preliminary assessment of your roads, and then we, as their legal partner, would then deliver to you a road use preservation law and an agreement template to be reviewed by the town board and adopted via local law that would also be reviewed by your town attorney and all of those things. So basically you get those 2 pieces in place and your program is ready to go and it's on the books and you can then go forward. And then when the and I have Melanie Chappell here also from Delta. She's yes. Right. Right. So, and that's an important piece because a lot of the questions that we often get are, okay, now I have this in place and I see a truck driving through the town. What do I do? How do I deal with that? And once I do get them, say I stop them or flag them down or they get pulled over by a trooper or whatever it is, what do we do? And so the training helps the highway superintendents, the town boards, and others that are going to be involved in how to administer the program when people come to town. And that's a big important part because, again, that helps you. The whole idea is to have you ready once this activity occurs and you're ready to go forward, and then the greater expenditure will be done on the developer's cost. Yes, ma'am.
Okay. I had actually a couple of questions.
Sure.
One is, and we heard Lynn Irwin talk about this earlier, that depending on the time of year, the road condition varies. In a way sort of related to that, we kind of know that there's just 2 seasons here. There's winter and there's construction.
Right.
Right? So when you're working out your agreement with the developers, can you make provisions that the upgrades have to be done during construction season and not during winter season? Or are they going to delay their projects, or what's the risk that they put in substandard roads because the road, in the middle of winter you can't put in a good road?
Well, let me go from your second question first. The issue of putting in a substandard road. If you have a program in place and you have engineering support and observations that are going on, you're going to be in a position where you can say that's not acceptable. Okay.
Right, but is building a road in the winter acceptable? Period.
If you developer choose to go forward under winter conditions, then you've got to take whatever steps are necessary to make that road be sufficient for its standards, and that's their responsibility and their choice. They can time their projects so that they don't have to do that, but it's not you holding them up, it's them choosing to do it, okay? Okay. And it's something that's why you want to have a program in place so they know, okay, I don't want to start this project or this part of the project in winter because I'm going to have to put 2 miles of road in and I can't do it up to standard. I'm not going to do it there then, or I'm going to start at a different time. And the developers, there's a lot of, like if you have a dirt road and you're doing it in April when you have snow, unlike this year, and those roads are soupy and muddy and nasty, that by waiting a month or so, they might avoid having to do anything to that road because it'll be suitable for them. But if they start right away, as soon as they can, then they're going to have to do a lot of different things to make sure the road is passable on an ongoing basis and dealing with it going forward. So that's that piece of your question. All right, and then the other part of the question was focused on, I'm sorry, if you repeat the first part.
I think it was all.
It was all kind of.
Yeah, it was all
wrapped
kind of
up.
Yeah,
okay.
I think that you've addressed that. The other question I have is that I understand the concept that you described of prorating for the damages, but again, at the front end of a project, you have one developer that gets involved, and so he gets assessed for the upgrade, and then 3 months or 4 months down the road, you couldn't have anticipated it, but somebody else now wants to use that same road that developer 1 paid for all the upgrades. What happens? Does developer 2 just gets the advantage of that?
Basically, under the terms of your program, generally that's what would occur. What would happen is as that upgraded road is used by developer 1 and 2, and it has to be repaired or fixed, or if it has to be taken out later, then that cost after developer 2 comes on the scene would be prorated between the two. Now, my guess is, knowing developers, that as soon as developer 1 knows that developer 2 is coming in and using its brand new road, they're going to be going to developer 2 and saying, fork over some money here because
so
you're
that's going to be between
that's
the two
a private
developers.
issue between
Okay.
them. But really what you're looking at is, from the town's perspective, is, okay, now we have a developer 2, developer 1 upgraded this road to handle their traffic. Will your additional traffic require any further upgrades, or will it require repairs sooner or differently than would otherwise occur with just developer 1? And those additional costs have to get rolled in.
Okay, good, thank you.
You're welcome.
This is a question both for Mike and for Mark, because of the different parts of it. So we've been talking a lot about road damage, but I think we all know that a lot of the negative impacts have a lot to do with the amount of truck traffic in terms of frequency, whether they be air impacts, traffic congestion, traffic safety. Are there any hooks in the vehicle or highway law, or have you seen any examples in road use agreements of limiting how many truck trips, say, per week? And I can imagine you might run afoul of interstate commerce law, but I just want to know what avenues do towns have to address what really is the biggest impact, which is a lot of trucks in a short period of time.
Well, you jump in, but I mean, one thing is, you're really talking not so much a road program or road preservation issue. You're looking at an overall community impact or environmental issue. Now, that's a whole different avenue outside the scope of what we're talking about, but generally there's a concept where municipalities, even though gas drilling is regulated by the DEC and the state's preempted local regulation of it, municipalities still have the power to adopt what they call local laws of general application that address issues that only incidentally affect gas drilling. Wetlands is a typical one. Air quality is another. Runoff is another. If you impose your own, if you adopt your own wetlands laws and standards, and that affects a gas drilling operation, that will generally be upheld, depending on the way it's worded and drafted. But that'll generally be upheld because it's meant to apply to anything. If someone's putting up a garage or a well, it doesn't matter. You can't go in the wetlands. We've created our own standards. If you create certain air standards or fugitive dust standards or things of that nature, those kinds of things can be done, but they have to be of general applicability. They can't be targeted at a particular industry. Mike?
Yeah, and just to the point of whether you can limit the amount of truck trips on a particular road, I don't believe that would be permitted under either the highway law or the vehicle and traffic law. But what you have seen in the development of some of these road preservation local laws is that it's the number of truck trips that trigger certain permitting requirements. So if they're making infrequent truck trips, then they wouldn't necessarily be required to get the permits. But some of the road preservation local laws will say that anybody who's going to make an excess of 20 trips over any 4-day period back and forth on these roads, or is expected to, will then be subject to the following limitations. So although you can't limit or restrict the number of trips, as Mark mentioned earlier, the vehicle and traffic law authorizes the free use of the highways of the state. You can use that as one of the triggers in your local law for some of these permitting requirements, to the extent if it's within those other regulations.
In some of the discussions, we've alluded to the developer improving the road or making repairs and so forth. I believe it's the case that, in fact, the municipality is the one that actually performs the work or has the work performed on the road, not the developer, correct?
No, there's options in that regard. And again, that's one of the things to be considered in your program. It doesn't have to be the municipality undertaking it. Often a municipality doesn't have the staff or the equipment to take over those types of repairs individually. They might have to contract out for some of that work, but generally the way it works is that the town retains control over identifying or approving the particular repairs that need to be done. And they have to meet certain standards that the town adopts, and they're based on engineering standards. Then they go to the developer and say, here's what you need to do. There's an engineering seal on this document, go do it. The developer then needs to go do it at their own cost. If the developer says, I can't or I won't, then the town can use the money that's put up in security to hire, either use its own forces or hire a third party in order to go and do that work.
Okay, I was assuming that the municipality would be the one to be hiring, and the developer would then pay the municipality. But you're saying in this case that the developer may in fact hire their own subcontractor
Absolutely.
and pay their own subcontractor as long as it meets the town's standards.
Correct, and that's often the way developers will try to proceed, because if they have a contract with a pavement or road company, then they can say, hey, listen, you need to perform on this schedule because this is what we're doing, and it keeps their overall project moving. If it's the town, then you get into an unfortunate situation where you almost become a contractor of that developer, and if you don't perform in the standard and time that they require, what happens? You have a legal fight, and you don't want to have that. So our recommendation is always either identify and have them do it, or identify and identify the problem, have them. You can either come up with an engineering solution yourself and have them do it, or have them come up with an engineering solution that's reviewed by your experts and then approved. It's just the amount of control that a town wants to have over those situations. Yes,
Coming right over. Gosh, you keep asking questions from one side. You're giving me exercise here.
it's not good cart golf.
Hold on.
Thank you.
How do you envision seeker coming into play here? Wouldn't the town have to comply with seeker before it issued a permit?
No, it wouldn't be. The way, well, let me step back. Generally, before you adopt the local law creating the program, you would have to comply with seeker. There's different ways to comply with seeker. You can either do an individual review for that local law in that town and say, you may either make a negative declaration or go through the environmental impact statement process. And then from there, you go forward, and when someone comes into town and you're going to enter into a road use agreement with them, then a seeker review would need to be done for that. The other option is to do a generic, follow the model of what's been happening in certain counties, particularly Sullivan County, where they've done a generic environmental impact statement. And what that does is you do that review process. It establishes mitigation measures and standards and criteria in that review that apply to any of these activities. So if an activity, a road use agreement, is going to be entered into that is compliant and consistent with those identified mitigation measures and requirements, no further seeker review would be necessary. So you have options under seeker, and your seeker review, remember, the scope of your seeker review is the road agreement, if you're entering into one, or the adoption of that local law. It's not the mall development, it's not the gas drilling operation. It's that for that particular purpose. If you're issuing a permit for a mall development as a town, that can get rolled into your overall seeker review. But if it's a gas drilling where you don't have an independent seeker review, then it would be, okay, you would have it just for the limited purpose of that agreement.
I just don't envision towns in this part of the state going through the generic environmental impact statement process just to write a local law for something like that.
Well, it's what happened in the past. You could very well be right. And what the thought process on it is that it was an important issue to these towns in Sullivan County. And they pooled their money together to have work done that they couldn't do individually. And so they went forward and went through this process, and it also it gave them exposure, both politically, for going through this process and being in the forefront of the issue. And that was something they desired to do and felt was a worthwhile expenditure. You don't have to do it. The one issue that we've talked about with towns is that, okay, now if your town board is the one that's entering into this agreement, your town board then has to do the seeker review. Town boards generally don't do seeker reviews, except for limited circumstances. So that's an unusual thing. So usually your planning board or your zoning board is doing that. So it's a cost or an effort that they have to go through that they may or may not want to do. So it's just something, an element to be considered in the context of your overall program. But a generic environmental impact statement isn't required. It's just an option. Right. So but you still do need to comply with seeker when adopting that law.
Okay, let me ask one more question, if I may.
Sure.
We've had 3 speakers and 3 different viewpoints on what the triggering mechanism should be for a local permit. So I'm just wondering if the 2 of you could summarize your views of where the trigger should be.
Sure, and again, that's the difference between the engineering trigger and the legal trigger for the application of the program. I can't speak to what the engineering trigger should be, the particular engineering standards that would be violated or upheld or anything of that nature. But in terms of the legal trigger of what makes your program apply to that activity, there's not one answer. There's a variety of different ways you can do it. As Mike said, certain towns are going and saying, well, if you have, you know, a truck of this weight and it makes a certain number of trips in a certain number of days, then you're subject to our law. You know, the other way we've done it is to identify what activity is the traffic associated with, and is it different than the baseline traffic that it normally occurs in that town, and then using engineering standards to support those conclusions. Either one of those are options that a town can consider, and each one has benefits and risks. And what you want to look at is, because neither the VTL, the Municipal Home Rule Law, or the Highway Law sets forth any specific criteria or specific standards you can point to, you're kind of creating new standards here. And you want to create one, in my opinion, that is the most conservative, that's going to let you achieve the goals of your program without subjecting it to potential challenge or successful challenge. Anything can be challenged, but is a successful challenge. So that's something that you have to talk about with your particular town attorneys or whoever you work with in order to understand what the risks of the particular proposals are. But that's the issue that you want to deal with is, am I running afoul of the restrictions within the VTL that say you can't impose fees, fines, licenses, permits to use the roads, but am I still within the authority given to me by the highway law to collect or recover damages to the roads caused by users on those roads? So sorry for the unclear answer.
I just think that question reflects the point that a one-size-fits-all approach is not necessarily going to work here. That if you adopt somebody else's local law, if you just take a model that's being circulated, you're taking it with everything included with their triggers, and they may not be right for your town. You may be expecting more truck traffic, less truck traffic, so that let's say 20 trips over a 4-day period may be too high or too little or wholly irrelevant based upon what the circumstances are for your town. So I think that when you're looking at what the triggers are, as Mark mentioned, you set the broad parameters. You know, at a minimum, you have to be in compliant with what's provided for in the vehicle and traffic law. You can't have any triggers beneath those thresholds. And then on the maximum, it's really going to just depend then on what your town needs, what local conditions require on that. Hold on, before we do get to one question, I just wanted to perhaps add on to a comment that was made earlier about whether the town prepares the road work or does the road work itself, or whether a contract's for it. And one thing that has to be considered there, if the developers are going to be doing the construction and the road repairs, it's still going to be considered a public work. You gotta make sure that you're paying prevailing wage, or that they're paying their subcontractors prevailing wage, and some of those other state mandated labor requirements, that they all have workers' comp insurance, all of that. You really want to make sure that those who are doing the work are informing that, let them bear the risk of non-compliance if they're going to balk on that. But as a town, you should be, if you're going to have anybody doing this work on your roadways, to make sure that they are in compliance with these other provisions of law.
And we've had specific discussions with towns and negotiating with developers on that issue. And they, of course, say, hey, we're a private company. We're using private contractors. Why do we need to pay prevailing wage? I don't want to do it. I'm not going to agree to it. My somewhat tongue-in-cheek response to them is, well, if you get your lawyers to give our town an opinion letter, which means that law firm is saying that that is okay, and if they're wrong, the law firm's insurance policy is on the line for any damages that might occur, then we'll consider it. And that never is going to happen. It's never going to happen. That's it's a negotiation point, but really it's something that, you know, our standard position is you pay, there's prevailing wage here, and that's just the way it is.
Go ahead.
Yeah, I have a question. We were talking about the cost of engineers, and you mentioned that You mentioned there are 3 phases, but you only gave the cost of the first phase.
Sure.
Can you mention the cost of the second
Well,
2 phases?
the cost I was talking really is phase 1 and phase 2. Phase 1 is the assessment of the roads. Phase 2 is the legal aspects of the legal documents and establishing the local laws. So that's that cost that we talked about. Phase 3 is, I can't give you an estimate on, and because it involves the negotiation of the road use agreement, if there's going to be one, whatever discussions are had with the developer in order to make sure they're in compliance, the engineering work associated with making sure that they're following the standards and doing all the things they need to do and preparing the documents for the upgrades and improvements that are necessary. All of those costs in what we'll call phase 3 are borne by the developer. There's an escrow agreement that's put in place that says the developer has to deposit X amount of money into an account, and that it's drawn down on, and when it hits a certain threshold, they have to deposit more money back in to do it. And so they get where they can avoid saying, well, this is an open-ended carte blanche to do whatever you want. They get the bills, they get copies of the bills after they're paid, they get to look at them, and if they have an objection to them, they have a means of addressing that with the town, saying, wait a minute, we think this is going way, we don't need to be doing all this, and it's not called for under our agreement. So that is the way it would work.
So I have one more question.
Right into the mic.
When we're talking about road use agreements and road preservation laws, is one option to have a road preservation law that sets the baseline and then have road use agreements with the individuals that you're talking? Is that one way
That's
to
exactly what we're
approach?
talking about. That's
Okay.
The law is to set the standard and make them come to the table. And they can either say, all right, I will comply with the standards of your law, or I'm going to enter into this agreement with you to lay out all the details of our arrangement together.
Okay, I have back to issues about triggers.
Sure.
Are the triggers defined as a broad swath of something that applies generally throughout the town, or can you have specific triggers for specific roads?
Well, again, it depends whether you're talking about engineering triggers or legal. If you're talking legal triggers of what you're subject to, then you're going to have one that applies across the board. You're saying this type of traffic is regulated. However you define that type of traffic, you can work with us or your own town attorneys to develop what the appropriate triggers are in that concept. But if you're talking engineering things, engineering standards that would apply to one road or parts of a road, or would it be different for each part of the road, that's an engineering question that you would want to work with your town engineer or people you hire in order to work to develop what those particular things are. Now, the timing of that and who pays for that is important. The initial baseline analysis that you do is going to look more at general classifications of the roads. They're going to look at, well, you have certain roads, certain mileage of this type that is more risky. You have certain mileage of this type that's less risky, and come into some sort of understanding of how to classify those roads. So if a developer comes in and says, I want to use that road and piece of this road for my haul route, you then understand, okay, we're going to need to look at this more closely, and they're going to understand when they identify that haul route, okay, we understand that's a more risky road and might require more work. So then they're choosing that road willingly and understanding that they'll be responsible for the cost of making sure that that improvement in that area is suitable.
Mm-hmm. Okay, so we have, in our town, we have a gravel pit.
Yep.
That you can certainly imagine will be used
Sure.
for a lot of different
Sure.
circumstances. It's pretty much a very small local road that pretty well just goes to the gravel pit.
Yep.
So the baselines there are, a lot of circumstances are, relative to that gravel pit are quite different than what we'd experience
Sure.
on other local roads. So is there a way to describe that
Yeah.
that's not just mechanical?
Well, you need to look at it from what is baseline traffic and what's the new traffic. When you go in, you wouldn't go into necessarily. What your question really is getting at is, can we make that gravel pit operator meet the standards of this law? And the question is, if it's
Well, actually, I'd like to insulate the operator of the gravel pit and have it be a cost that's borne by the developers
Okay.
that use the pit.
In that context, the developer that's coming in and says, I need 10,000 trucks of gravel for my project, and creates that demand for the traffic, they're the ones that are going to be responsible under these programs for any upgrades to that road. It's not the gravel operator.
Right.
It's going to be, and that's a much easier model to deal with because they're the ones bringing that traffic on. Whatever existing traffic is going in and out of that gravel pit is really going to fall into most likely a baseline traffic analysis. And it's the new traffic on top of it, which would be the concentrated traffic that would then be regulated.
And so over what period of time do you determine a baseline? I mean, you know, we haven't had these kind of road use agreements in the town before, and the gravel pit has certainly accommodated large construction projects before, so.
Well, basically what it would be is, and again, if we're not talking about gas drilling, all right, and there's a large construction project in your town that gravel pit is servicing, that large construction project is going to have a seeker review for whatever, unless it's permitted as of right and there's no permits required, they're getting a building permit, there's going to be a seeker review that's required. And part of that seeker review should be an analysis of the construction impacts related to that project. The construction impacts, one of the main ones is going to be construction-related traffic. Not just where, not just how, what are the delays, it's where is it coming from, what are the impacts to the road system that it's going to use. And you can go through the analysis using the standards in the road preservation program and apply them to this particular scenario so that that project, at the end of the day, is meeting the standards of your local road preservation program so that the road is evaluated, improved, restored, maintained, and then evaluated for future longevity. Does that help?
Sort of. I guess it didn't quite get to the question of what's a baseline for a road like that.
That's an engineering question that needs to be evaluated based on its current use. Each individual one is going to be evaluated against engineering standards to identify what the baseline is.
Okay.
Okay. If you wanted to create a program tomorrow, and you got your engineers to go out and look at the traffic on that road, they could then create a baseline. So in the future, if that project comes in, you have a baseline against which to compare it.
Okay, but so the baseline is just what's happening currently?
Correct. It's the general traffic that's going to occur, except for if there's certain particular construction activity that could otherwise be captured.
Okay.
Right, if the gravel pit's servicing other projects.
Right. Okay.
All right.
Thanks.
Thank you. So I want to thank Whiteman, Osborne, and Hannah. And
I have a question.
it's okay. I am not done yet. You can still have a question. Whiteman, Osborne, and Hannah, and also Delta Engineering for all the groundbreaking work they've done in this area. I know that Delta's name has been brought up a lot. I just want to let you know that there are actually a number of engineering firms out there. That's not the only one that's interested in this work, in case you are looking at this. The other thing that some municipalities are doing is slugging it out on their own, trying to determine the amount of baseline traffic that's happened by having road counts, trying to determine the road carrying capability of the road by actually having, when a culvert's replaced, whatever, they determine what the section looks like, and then are having an engineering firm do the road calculation just to help get some idea of where the triggers might be. So there are things like that out there, but I don't want to minimize is the administration part of this, which is huge. And most likely any small town is going to have to collaborate with a number of other ones in order to make that happen. So just if you are thinking about this and thinking through the whole process, the engineering part you may be able to get away with doing on your own, but after that, by hiring out someone. But when it comes to the administration part, it's huge. There's a lot going on here, so not to leave that away. And the question I want to ask then is dealing with bonding. When Lynn Irwin showed his graph of condition over time, he mentioned that if you go down the curve a little bit and then you upgrade it, you can keep the road in pretty good condition without spending a lot of money, which means you'd have less money they'd have to post for a bond. Are there bonding, have you worked, either one of you worked with bonding construction, they would say that if they are maintaining it on a daily, weekly, bi-weekly basis, that the bond would be a certain amount, and if they let the road go to hell, it's going to be a lot different?
I haven't dealt with that personally in that particular context. Where we have had some flexibility is as a project goes forward and you say, okay, you have 100 miles of road that you're dealing with and you're going to have to put up a bond sufficient to cover anticipated repairs over that network. Well, say the project's moving through the town from north to south, and as they go through, they're going from 100 miles to 90 to 80 to 70 to 60 and so forth, and they're using less and less and less and less of the roads, and the others have been repaired, and you've signed off on them and saying they're good to go, they're fine, they're no longer part of the project. Then you can, if the developer requests a reduction in the bond amount, because it's now no longer covering all that other aspect, that can be negotiated and reduced in that amount. I've never dealt with because you want it, the bonding amount you're setting in the first place should be assuming that level of repair and attention is being paid to the roads, so that you're performing under the agreement to maintain the roads in a good condition, a passable condition, and that if the correct improvements are being made, at the end of the day, you're going to minimize any cost or damage that might be at the tail end of the project. Sometimes you can avoid it, sometimes you can't. So, but that's a very tough sliding scale, because what if it changed? What if you let them reduce the bond amount because there's been good performance, and then all of a sudden they bring in a new contractor, and that contractor's terrible, and now you're stuck having to negotiate a new bond agreement? You might be successful, you might not. You might end up at, why put yourself in that position? I'd rather have a sufficient bond in place in the first place, and then as completion of the project is done, then you can consider that if it's requested.
And I would only add to that that a lot of the local laws will require that any bonds or money that's put in escrow or anything like that be replenished once it hits certain minimum thresholds. So you might require a bond of $200,000, $250,000, and then as that draws down, once it hits $50,000, now they have to replenish it back up to $250,000, so that you don't require one large upfront bond for everything without any mechanism of recovering it. They're putting up, by minimizing the amount of the bond that they could put up, they may be more willing to do so, freeing up some more capital for them, meanwhile replenishing it as time goes by and as circumstances warrant.
Other questions? I'll ask mine.
There you go.
I'm feeling a little bit at sea
Okay.
with respect to New York State law
Okay.
in general, and the notion of preemption and the hierarchy of law. Is the environmental conservation law considered a general law? When you use the term general.
Well, in the context of roads, the provision of the environmental conservation law exempts local roads out of that preemption altogether. The environmental conservation law is a general law of applicability throughout New York State. Okay, it applies to whatever regulated activities, wherever they are in the state, as long as the resources that are identified are involved. Okay, so it's a situation where the provision relating to gas drilling has a specific exemption that says we preempt everything except local roads and real property taxes. So it's kind of, you should feel at sea in New York law because it's as clear as mud. As you know, both Mike and I have spent time talking about the way the vehicle and traffic law is set up and how its primary goal is to promote the open passage of traffic. Then it has all these carve-outs of things you can do, but then those carve-outs are undermined by the provision that you have to provide free and flow of traffic. So it's not a clear area where it's dealt with these kinds of things, which is why it's fallen to municipalities to come up with these answers themselves.
Is vehicle and traffic law and municipal home rule law preempted by, in those clauses, general law? You use the term general law, and I'm trying to find out the distinction between general law and VTL.
A general law
and
is one of general applicability across the state. So what it says, the municipal home rule law gives you the ability to adopt standards that are different, so long as they're not inconsistent. So if the state says you can have a vehicle of 20,000 pounds or 40,000 pounds as a legal limit, you can adopt. Well, that's not a good example. Let's say it says you can regulate something this way. You can allow hours of operation, or you can do these kinds of things. You can allow these types of uses. You can have these types of resources be impacted. You can have a local law, like for example, wetlands. If the state says we regulate all wetlands that are 12.4 acres or larger, a local town can say, well, I'm going to regulate wetlands that are smaller. I'm going to say 1 acre. Any wetland of 1 acre within our town is going to be regulated, and you need a permit from my town in order to put any fill in a regulated wetland. So that would be a law. That general law is the general state regulations pertaining to wetlands. The local law is the local law saying we're gonna regulate something more than what the state requires. Now that's not inconsistent under New York state law, because you're regulating the same thing with the same manner, but you're just identifying something that's a little more stringent. It's a local issue. And so it's kind of that, they don't want standards. They don't want to say, well, we'll allow this specific kind of fill in our town, but you can't have that in the rest of the state. You know, it's a very less than clear concept. You want to take a stab?
Just to show how less than clear it is, and don't feel bad for being lost on the issues of preemption and home rule, because I'm sure that the attorneys for Anschutz and Holstein Corporation are going to be arguing that the Supreme Court was confused on the issue of preemption and what is preempted and what's not. But you have, when you're talking about preemption, you're talking, especially in a home rule sense, when we're talking about it has to be consistent with general laws. That's in contrast to special laws. Right. So you have general laws and you have special laws. And the vehicle and traffic law could have sections that are both general laws, or it could have sections that are special law. And a special law is a law that's going to apply to some, but not all, of a particular class of local government. So if it applies... A particular class of local government. Thank you. So if you have, for instance, local speed limits, let's say, if you have some towns that could, in fact, adopt speed limits and other towns that can't. So if the law says that, you know, well, actually, that applies to the whole class. Bad example. But there are, if a law says that all towns, except for the town of Brookhaven, can adopt truck routes. Well, now that's a special law because it doesn't apply to all towns in terms or effect in the same way, which means that a local law doesn't necessarily have to be consistent with that. Now, that's one of the aspects. That's consistency under the municipal home rule law. So when we say that it has to be consistent with the general laws of the state, we're talking about if it's a law that applies to the entirety of a class of local government, it has to be consistent with it. But then you layer on top of that preemption, which is the language that you saw in the vehicle and traffic law. And now if you have field preemption, and it says that vehicle and traffic law, we occupy this whole field of that. There's no room for local laws except for what we specifically provide here. Well, now you've got pretty much field preemption, and you're going to be pretty much channeled into working within the parameters that the vehicle and traffic law defines. Now, again, going back to the vehicle and traffic law, it says, except as otherwise provided in this chapter, which is the vehicle and traffic law, which then authorizes reasonable regulations subject to the various limitations of the various laws of the state, which to some will bring you back to the home rule component, in which case it would only have to be then consistent with the vehicle and traffic law. So it's somewhat circular in this respect.
It is circular.
And which kind of adds to the confusion. And because it's never really been a pressing issue until recently, I mean, we haven't seen the kind of development, the kind of heavy development that has occurred with wind turbines that's perhaps will be occurring with the gas drilling. So there's not a lot of case law developing this that kind of helps us navigate through that circle. So it's still, part of the reason it's confusing is because it is circular, and we're still trying to navigate through that. Yeah. But
the notion in the environmental conservation law uses the term shall, and it is specific to gas drilling industry and not wind turbines and. When we're putting together a law of this type, we have to be consistent across all industries that we consider to be heavy or that come through as triggered.
Yeah,
so how does that relate in this? I bring it up because you showed the slide, specific to gas drilling. Well, yet we're writing a law that is not specific to gas drilling.
Well, right, and the reason we raised that issue in showing you the slide with the gas drilling is because if you, across the board, any activity, wind development or otherwise, will require a permit from you as a town in order to occur in your town, if you so choose it under your zoning. If you allow it, and then you can make it a permitted activity. And you have to issue a permit, and then you have control over what's going on. The difference here with the ECL provision regarding gas drilling is the state has taken that away from you as a local government and said, we are going to deal with the regulation of gas drilling, except for this provision of local laws. So really what they're doing is they're taking that piece of the natural gas project, putting it down with all the other projects that you deal with, and giving you the right to regulate only that aspect of it.
Okay.
Does that help?
Thank you. Yes.
So here we are, it's noon. You all made it through, so congratulations on that. Can we give our panelists an applause? Thank you both Mark and Mike, and Lynn Irwin's in the back there. So you have Mike's contact information, and Lynn Irwin, you got his earlier from Cornell Local Roads. You said just go local roads and Cornell will come up on top. Mike Keneally from the Association of Towns, he's available for town support at any time. Lynn just came in and said the weather's not that great outside, but he did pass out a handout on the falling weight deflectometer. He has David Orr in the back with a raincoat on, who I think he wants to maybe, he'll be right back there and you can visit with him. He'll talk to you a little bit about what his falling weight deflectometer does, so when you go outside, you can actually see it and then run off to your car. So with that, I want to thank you all again for making this a priority in your day, and we have great resources here. This is not an easy issue. Good luck with it. Thank you.